In this lecture, we would like to discuss about Article 370 of Indian Constitution, which was removed in the year 2019. So, what exactly that article was? It was incorporated into the Constitution of India on 17th October 1949, and it exempted Jammu and Kashmir from the Indian Constitution with the exception of Article 1 and Article 370 itself, and it granted the state of Jammu Kashmir to draft its own constitution. It restricted the Indian Parliament's legislative powers in respect of the state of Jammu and Kashmir. So, the very instrument of accession which came into play when the Indian Independent Act 1947 divided British India into India and Pakistan for some 600 peninsular states whose sovereignty was restored on independence. The Independence Act 1947 provided for three options: either to remain an independent country or to join Dominion of India or the Dominion of Pakistan. And that was joining with either of the two countries was to be through an instrument of accession. So, the royal Raja Hari Singh had initially decided to remain independent and sign standstill agreements with India and Pakistan signed it. But following an invasion from tribesmen and army men in plain clothes from Pakistan, he sought the help of India, which in turn sought the accession of Kashmir to India. So Raja Hari Singh signed the instrument of accession on October 26, 1947, and the Governor General or the Viceroy Lord Mountbatten accepted it on October 27, 1947. So, exactly where in the Constitution this provision was there, as we found that Article 370 of the Indian Constitution is a temporary provision which grants special autonomous status to Jammu and Kashmir. So at present we found under Part 21 of the Constitution of India, which deals with temporary, transitional, and special provisions, the state of Jammu Kashmir had been accorded as special status under Article 370, and the very presidential order of 1954 dealing with Article 35A, which was particularly in relation to citizenship and on buying land and property in the state. So it was removed on 5th August 2019 as Indian President issued a constitutional order superseding the 1954 order and making all the provisions of the Indian Constitution applicable to Jammu and Kashmir. After the resolutions passed in both the houses of Indian Parliament, the President issued an order on 6th August declaring all the clauses of Article 370 except Clause 1 to be inoperative. And this is the first time the Article 370 has been removed, and it was being used to amend Article 367, which particularly deals with interpretation in respect of Jammu and Kashmir, and this amendment has been used to amend Article 370 itself. So, we would like to analyze the very position of the state of Jammu Kashmir before the presidential order of 2019. So, before the order of the president being issued in 2009, Article 370, which was providing a special status to Jammu Kashmir, was dealing with dual citizenship. So, the very state of Jammu Kashmir then was having a separate constitution, and also all the residents of state of Jammu Kashmir were first the citizen of Jammu Kashmir, then the citizens of India. So also there was a separate flag for Jammu and Kashmir, and besides that there was no reservation for such minorities in Jammu and Kashmir like the Sikhs and Hindus, and some special powers are exercised by the state of Jammu and Kashmir and its legislative assemblies. So also the financial emergency, which is a part of Indian constitution under Article 360, was not applicable to the state of Jammu and Kashmir. Then also the very duration of the state legislative assembly was 6 years, and also Indian citizens cannot buy land or property in the state of Jammu Kashmir. And also, if a woman from Jammu and Kashmir married out of the state, she would lose the citizenship of the state. Besides that, the constitutional provisions dealing with the right to education and those statutory enactments were not applicable to the then state of Jammu and Kashmir. So also, right to information and the concerned statutory enactments would not be applicable to the then state of Jammu Kashmir, neither the panchayats in Jammu and Kashmir had any constitutional rights or power. But after the presidential order and the enactment in parliament in 2019, at present, there is only single citizenship. So any resident of this Jammu Kashmir is a citizen of India. No more is having the double citizenship of the state. And also at present there is no separate flag, there is only one common national tricolor flag, and at present also 16% of reservation are provided to those minorities such as the Sikhs and Buddhists, and at present the state has divided into two Union territories as Union territory of state and of Jammu and Kashmir and the Union territory of Ladakh, so there is no question of any special power of such legislative assemblies. And so also at present, the financial emergency under Article 360 is applicable to the Union territories of Jammu and Kashmir and Ladakh, and also peoples from other states of Indian Federation will now be able to purchase or buy any land and property in the Union territories of Jammu and Kashmir and Ladakh. And duration of the concerned assemblies at present would be 5 years only. So also, any women from the Union territories, even if she married any other Indian citizens, or if even she married out of the state or country, would not lose her citizenship. And at present also the right to education. The concerned statutory acts are now applicable to the Union territories. So also the right to information act and those statutes would be applicable to the state of Jammu Kashmir. So what exactly this article provided? It is the first article of Part 21 of the Constitution, which was then heading, and also at present it is entitled as Temporary Transitional and Special Provisions. And that particular Article 370 could be interpreted as temporary in the sense that Jammu Kashmir Constituent Assembly had a right to modify or delete or retain it. It decided to retain it. Another interpretation was that the accession was temporary until a plebiscite. So, the Article 370 Clause 3 permits deletion by a presidential order. Such an order, however, is to be preceded by the concurrence of the Jammu Kashmir Constituent Assembly. Since such an assembly was dissolved on January 26, 1957, one view is that it cannot be deleted anymore. But the other view is that it can be done, but only with the concurrence of the State Assembly. And the very present status that we found Article 3 of the Jammu Kashmir Constitution declares Jammu Kashmir to be an integral part of India. So, in the preamble to the Constitution, not only is there no claim to sovereignty, but there is categorical acknowledgement about the object of the Jammu Kashmir Constitution being to further define the existing relationship of the state with the Union of India as its integral part thereof. Moreover, people of state are referred as permanent residents, not citizens. Article 370 is not an issue of integration, but of autonomy. And exactly what is the provision of Article 35A? Article 35A, which stems from Article 370 and was introduced through a presidential order in 1954, Thus, that particular Article 35A does not appear in the principal body of the Constitution. Article 35 is followed by Article 36 but appears in Appendix 1. So, Article 35A enables the state of Jammu and Kashmir Assembly to define the permanent occupants or residents of the state and their extraordinary special rights and privileges. The presidential order has extended all provisions of the Indian Constitution to Jammu and Kashmir, including the part on fundamental rights. Along these lines, the discriminatory provisions under Article 35A are now unconstitutional and illegal, and also the Supreme Court examined it as unconstitutional or violating the basic structure of the Constitution. And as Article 35A was not passed as per the amending process given in Article 368 of Indian Constitution but was inserted on the recommendation of the Jammu Kashmir's Constituent Assembly through a presidential order. So it could be removed at any time, and as such it was removed by the presidential order and by the enactment of the Parliament of India in 2019. And now in that connection, we would like to discuss certain landmark judgments delivered by the apex court. So in that particularly, you would like to discuss the first important leading case, and that is Premnath Kaul case 1959. A five-judge bench of the Supreme Court observed that Article 370, Clause 2 shows that the continuance of the exercise of powers conferred on Parliament and the President by the relevant temporary provisions of Article 370, Clause 1 is made conditional on the final approval of the Constituent Assembly of Jammu and Kashmir. And the next important leading case relating to Article 370 is the Sampat Prakash case in 1968. The apex court decided that Article 370 could be invoked even after the dissolution of the Constituent Assembly of Jammu and Kashmir. So Article 370 has never ceased to be operative, the five judgments expressed. And now we would like to discuss another important leading case, State Bank of India versus Jawaharlal Nehru in 2016. The Supreme Court observed that the federal structure of the Constitution is reflected in Part 21. The court also said that Jammu and Kashmir has a special status and that Article 370 was not temporary. The court referred to Article 369 of Part 21 that specifically mentions the period of 5 years. No time limit is mentioned in Article 370. The court further observed that Article 370 cannot be repealed without the concurrence of the Constituent Assembly of the state of Jammu Kashmir. And now we would like to discuss another important leading case, that is Kumari Vijayalakshmi Jha versus Union of India in 2017, where the Delhi High Court rejected a petition that argued that Article 370 was temporary and that its continuation was a fraud on the Constitution. And in April 2018, the Supreme Court said that the word temporary in the head note, notwithstanding Article 370, was not temporary. And the last most important leading case is the leading case of Santosh Kumar in 2017. The apex court said that due to historical reasons, Jammu and Kashmir had a special status. So, after discussing all these landmark judgments, now we would like to discuss those particular changes made after the presidential order of 2019 issued on August 6, and those changes are the first one, the state of Jammu and Kashmir will now cease to exist. It will be replaced by two new union territories, Jammu and Kashmir and Ladakh. And the second one, union territories have become states earlier. This is the first time that a state has been converted into a union territory, as we found the basic provisions under the Indian Constitution relating to Article 2 and 3 and 4 of the Constitution. The Union Territory of Jammu Kashmir will have an assembly like in Delhi and Puducherry. Kashmir will no longer have a governor rather a lieutenant governor like in Delhi or Puducherry. Article 3 of the Constitution gives Parliament the power to amend the Constitution by a simple majority to change the boundaries of a state and to form a new state. So Jammu and Kashmir lost its special status. Jammu and Kashmir has been given a status lower than that of other states. So at present, instead of 29 states in the Indian Union, now India will have only 28 states. It is also likely that corporates and individuals will be able to buy land in Jammu and Kashmir. Non Kashmiris might now get jobs in Kashmir. So, these are the fundamental changes we found after the removal of Article 370 of the Constitution, providing special status to the state of Jammu and Kashmir. After the presidential order issued on 6th August 2019, after enactment relating to removing Article 370, which was enacted by both the houses of Indian Parliament. So, in this particular lecture, we have briefly discussed about the position of Article 370 before the presidential order of 6th August 2019. So, also the position of at present after the order of the President of India in 2019. So, also we have discussed the instrument of accession and the very provision under Part 21 of the Constitution, and also some landmark judgments relating to Article 370 of the Constitution. So also those fundamental changes that we found After the removal of Article 370 from the Constitution, which was providing a special status to the then state of Jammu Kashmir,